Welcome to NIOS live classes. Subject: Political Science Senior Secondary. Code number 317, Module number 3, Structure of Government. Lesson number 12, Supreme Court of India. Outcomes. After study this lesson, learners will able to appreciate the role of the Supreme Court of India as guardian of the Constitution and protector of fundamental rights. First, we will study what is guardian of the Constitution. The Constitution of India is the supreme law of the land. And the Supreme Court is its interpreter and guardian. It does not allow the executive or the parliament to violate any provision of the Constitution. It can also review any action of the government which allegedly violates any provision of the fundamental rights. This power of the Supreme Court is called judicial review. If it finds violation of any provision of the Constitution, it may declare the concerned law of ultra vires or null and void. It is on the basis of this power of judicial review, the Supreme Court, that it is called guardian of the Constitution. It is also called a champion of liberties and a watchdog of democracy. Role and the functions of the Supreme Court. The Supreme Court has concurrent right with the High Courts to issue directions, orders, and rights for enforcement of fundamental rights. These are in the nature of the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. These writs make the Supreme Court a protector and guarantor of fundamental rights. The idea is that in case of violation of a law or right, the court may direction issue for compliance with the Constitution. Thus, the citizens of India are secure as far as fundamental rights are concerned. The Supreme Court has the right to declare a law passed by the legislature null and void if it encroaches upon our fundamental right. It has rejected many legislations which violated fundamental rights. This shows how the Supreme Court has always served as the guardian of fundamental right. Now we will look what is writ. It is an order issued to a lower court or a functionary of the state to take steps to restore rights of the people. Review of its own judgment. If the Supreme Court discovers that there are some new facts or evidence, or it is just satisfied that some mistakes or error took place in its previous decision, it has the power to review the case and alter its previous decisions. This is generally done when a review petition is filed. Normally, review is done by a bigger bench, that one that originally decided the case. Judicial review. It is a process through which judiciary examines whether a law enacted by a legislature or an action of the executive is in accordance with the Constitution or not. The power of the judicial review was first acquired by the Supreme Court of the United States. Now it is freely exercised by the Supreme Court of India and in many other countries. Or high courts also exercise this power. But judicial review does not mean that every law passed by the legislature is taken up by the Supreme Court for review. It only means that the court will review the law as and when it gets an opportunity. This is possible in two ways. First is the court can review the law if its validity is challenged. The Supreme Court or High Court may get an opportunity to review a law in another situation also. If a person or institution feels that his or her rights are violated or a certain benefits due to him under a law is being denied, the court, while examining such a petition, may come to the conclusion that the law under which relief is sought in a democratic country like India, the power of judicial review is an important guarantee of the rights of the people. Besides, the Supreme Court has been interpreting various provisions of the Constitution. Its rulings are treated as law of the land. Supreme Court as a custodian of fundamental right. Supreme Court plays its role as the custodian of the civil liberties and in particular of the fundamental rights. The right to equality is an important right which ensures equality before law. The right to equality also means absence of special privileges and equality and inequality of treatment, whether it is related to education, jobs, etc. So the Supreme Court, in the name of protective discrimination, has justified that the benefits or concessions in the form of reservations or relaxation of eligibility conditions, reservation of ST/SC in jobs or admissions, etc. The right to freedom has given various kinds of freedom to all of us. For example, freedom of speech and expression, choose any religion, etc. But the freedom of press was not mentioned in the Constitution. It was decided by the Supreme Court that freedom of press as a right is implied in right to freedom of expression. Thus, the court expanded the right to freedom. It's time for a break.
परीक्षा पे चर्चा प्रतियोगिता 2026 में आपका स्वागत है। शिक्षा मंत्रालय भारत सरकार का यह विविध सहभागी
Welcome back to our classes. As we know that Supreme Court has regarded the right to know was an important right to be able to take part in the participatory process of development and democracy. The court has ruled that the right to life in Article 21 implies and includes the right to education and clean environment also. Regarding the delay, in deciding the case, Supreme Court has held that delay in trial constitutes denial of justice. It has also laid down that speedy trial, release on bail of under trials. Free legal aid to the poor and accused are also the fundamental rights. The Supreme Court has used its power of judicial review and given various historic decisions to safeguard the right of the individuals. It has stood guard of linguistic rights of minorities, religious right of the people, welfare of the workers and daily wage earners. It has also taken action to protect bonded labor, prevent exploitation of women, children and deprived sections of the society. The power of judicial review is an important guarantee of the rights of the people. It does not allow any violation of the Constitution. It has given several new interpretations to the constitutional provision. Thus, it has protected as well as expanded the Constitution. Next is judicial review. Supreme Court, though its power of judicial review has guarded our rights in various walks of life. The Supreme Court has given momentous decisions, though what is called judicial activism. For example, Supreme Court takes up a case related to environmental concerns like choosing of factories in Agra to protect Taj Mahal. The court has given such rulings as compulsory use of CNG fuel for the use of public transport vehicles in Delhi, so that the pollution could be brought under control. Similarly, for the protection of lives of people, it has made the use of helmets compulsory. Helmets for two-wheeler users and even the pillion riders. Now we will look what is PIL, Public Interest Legislation. The judiciary, including Supreme Court, entertained legislation only from those parties that were affected directly or indirectly by it. For example, people of Delhi filed PIL for protection of environment, which brought up the use of CNG run vehicle. It heard and decides cases. But subsequently, the court permitted cases on the ground structure of government of public interest legislations. It means that even people who are not directly involved in the case may bring to the notice. PIL, Public Interest Litigation. It is the privilege of the court to entertain the application for public interest litigation. The concept of PIL was introduced by Justice P.N. Bhagwati. PIL is important because justice is now easily available to the poor and weaker sections of the society. The Supreme Court, on the basis of letters received from journalists, lawyers, and social workers, and even on the basis of newspaper reporters, has taken up a number of matters of public interest. Under PIL, the right of under trial held under illegal detention have been restored. The Supreme Court ordered the release of many detainees without trial on the ground of their personal liberty, which could not be curbed due to judicial or bureaucratic inefficiency. It's time for a break.
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। जीवन ये प्रकाशित करने राहों को आलोकित करने।
सीमा से विद्यालय जो मुक्त हो, संसाधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो,
कभी पढ़े हम कहीं
ज्ञान ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा और परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बहुत,
कोई मन चाहा केंद्र चुने, हम अपना जीवन स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने, स्वयं बने, हम
Welcome back to our classes. The Supreme Court has also taken up the steps to free bounded laborers, tribals, slum dwellers, women in rescue homes, children in juvenile home, child labor, etc. In case of environmental pollution, the Supreme Court has ordered closure of a few factories near Kanpur, Delhi and other places also. With more and more decisions coming from the Supreme Court, the scope of PIL has widened. Now a person can approach the court through a letter. And if the Supreme Court believes that the matter is of public interest, it can consider the letter to be a petition and direct the hearing of the matter so that public interest may be protected. The process of PIL has led to increased judicial activism. We have completed our lesson, so we will do some exercise for better learning. First, fill in the blanks. The judge of the Supreme Court are appointed by the President. The Supreme Court judges retire at the age of, and the answer is 65. The dispute between two or more states is brought before the Supreme Court under its jurisdiction, its original jurisdiction. The Supreme Court is dash to give advice to the President of the India. It's not bounded. Thank you.